viewing the Parliament Channel 11, also broadcasting on 105.5 FM.
In 1946, there was no ink into which voters were required to dip their fingers. Voting ink did not appear at the polling booth until 1956, when it was introduced as a deterrent against voting fraud. That year, some persons refused to dip their fingers into the ink, resulting in their ballots being destroyed.
You're viewing the Parliament Channel 11, also broadcasting on 105.5 FM.
Two to 4 Knox Street has been the site of a municipal building since 1899, when this key area around Woodford Square was home to several significant political and religious buildings. The present City Hall is a distinguished example of 1950s architecture, which reflected a move away from traditional colonial styles towards a more modern and functional aesthetic. In 1899, Cocoa Baron and Deputy Mayor Leon Agostini sold the property to the City Council for the sum of $38,000, and from then on it has been used for municipal purposes. Between 1899 and 1907, the Town Hall housed barristers' chambers, club rooms, and governmental department offices. A devastating fire in 1948, however, destroyed the building, and as a result, the administration of Port of Spain was conducted from the Prince's Building, which was at the south of the Savannah. Architects Pryor, Lorenco, and Northnagel were hired to design the new town hall. The architecture of the building came out of the post-World War II modernist movement. Trinidad and Tobago was developing quickly, and independence was in the air.
The Speaker.
Leader of the House.
Madam Speaker, in accordance with Standing Order 15.5, I beg to move that the House continue to sit until the conclusion of all the matters before it.
Honourable members, the question is that the House continues to sit until the conclusion of all the matters before it. Those in favour say aye. Aye. Those against say no. I think the ayes have it. We shall now resume to committee.
Yes, we could.
Members, the sitting of this committee is suspended till a little later in the proceedings. We shall resume to the sitting of the House to do other matters and return to this because the amendments to be circulated have not as yet reached members. Okay? Yes. All right, so this sitting of the committee is suspended. We shall resume to the House. Attorney General.
Madam Speaker. Madam Speaker, I beg to move the following motion standing in my name. Be it resolved that the Senate amendments to the Criminal Division and District Criminal and Traffic Courts Bill 2018 listed in the appendix to the order paper be now considered.
Honourable members, the question is that the Senate amendments to the Criminal Division and District Criminal and Traffic Courts Bill 2018 listed in the appendix to the order paper be now considered. All in favour say aye. Aye. Any against? The ayes have it.
Clause 3. A. Delete the definition of child. B. Delete the definition of children court.
Attorney General.
Mr. Lee, you want to vote together?
Clause 24.1. A. In paragraph A, delete the word "and" after the word subsection 2, semicolon. B. Insert the following paragraph after paragraph A. B. For the hearing of traffic violations, semicolon, and C. Renumber paragraph B as paragraph C.
Attorney General.
Thank you, Madam Speaker. Madam Speaker, I beg to move that this House agree with the Senate in the amendments to clauses 3 and 24(1) of the Criminal Division and District Criminal and Traffic Courts Bill 2018. Madam Speaker, the amendments brought from the Senate are entirely innocuous. In Clause 3 of the bill, we propose the deletion of the definition of child and deletion of the definition of children court, simply because in the interpretation section, the presence of these particular terms find themselves only there. There is no other reference to the child or to children court elsewhere in the bill, and in those circumstances, the definitions are not only superfluous but otiose. That is the rationale for the amendment in the deletion of those two terms. With respect to Clause 24(1) of the bill, the amendment is essentially simply for the insertion of a new subclause B, and Clause 24 really is the crux of the bill. Clause 24 allows for the Rules Committee established under Section 77 of the Supreme Court of Judicature Act to make rules of court, firstly establishing criminal courts, procedure for the management of case types and offences. Translated, that means specialist courts. And secondly, we now, out of an abundance of caution, in the Senate amendments, propose the insertion of the ability to make rules for the hearing of traffic violations. I remind Madam Speaker that in the amendment to the Motor Vehicle and Road Traffic Act, in making the insertion of a new clause, sections 20A, B, and C of that legislation, we bifurcated the manner in which offences were treated with. Some are kept as offences, and the vast majority of offences have been converted to violations. In those circumstances, the Ministry of Works and Transport asked for the inclusion expressly of the ability to make rules for the hearing of traffic violations, even though one could have dealt with that under the general provisions under Section 24(1)B as it now stands for making rules generally for the carrying of this act into effect. These amendments are therefore innocuous. They help us to advance simply a little bit more clarity in the bill, and I beg to move.
Honourable members, the question is that this House agree with the Senate in the amendments to clauses 3 and 24(1) of the Criminal Division and Traffic Criminal and Traffic Courts Bill 2018. Member for Point Appeal.
Thank you, Madam Speaker. I don't prepare to be long on these two simple clauses, but I would just like to ask a question to the Attorney General in his winding up. As part of 24(1), B for the hearing of traffic violations, there's coming out of the other place, there was an area of setting up a special criminal court in relationship to this. Could he, at his wind-up, shed some light into what that would be, and basically that, and what the authorization of the whole aspect would take place? With those few words, Madam Speaker, I thank you.
Attorney General.
Thank you, Madam Chair. I thank my learned friend for a very succinct contribution, and I move directly to answer my learned colleague. Section 24, Clause 24 of the bill, is the part of the bill, when it becomes law, provides for the establishing of special courts. The Supreme Court of Judicature Act and the Summary Courts Act allow for, together with the Constitution of Trinidad and Tobago, for the management of court by the Honourable Chief Justice, both in the appellate and High Court divisions, as well as in the Summary Court divisions. All that is essentially needed, therefore, is simply rules for the establishment of specialist courts. The specialist courts that are proposed to come into operation are very important for the advancing of the case management and criminal justice system. There is need for a special fraud court. There is need for a special court to treat with matters such as sexual offenses. There's a need for special courts to treat with certain types of children matters, even though we have a family and children division. In these circumstances, this bill allows for the first time for the creation of specialist arenas that the country has been crying out for at least 30 years. This particular clause allows for us to move past the umpteen bills that both opposition and government in that revolving door that they have stood over the many years have brought to Parliament. That is the drug treatment court, the drug court, the kidnapping court, the bail court, the gun court. All of those names and courts are now all rendered useless, because all that was really needed was the power to do these things prescriptively by the rules. Specifically with respect to traffic violations have to be managed. The government has already built out the information technology platform to do that. The Ministry of Works and Transport has digitized every single driver's permit in its database. They have digitized the records for licensing of vehicles, the registration plates, and the IT technology which operates between the judiciary, the spot speed cameras, the Ministry of Works and Transport, the traffic officers, and the court are now on a platform that works together. In those circumstances, the rules allow for us to create the management of traffic violations. After all, at a certain point where your points have crossed a certain position, you may be debarred from your license, you may have to appear before the court. Certain procedures that will have to be perfected are most nimbly accomplished by the use of rules. We intend, very shortly, to bring a standalone piece of legislation to quicken the process of electronic payments, specifically for the licensing division. We cannot, as a country, afford to wait for the technocratic team that has been working since 2011, when the legislation came to effect, electronic payments, because that exercise is too long for the whole of government. It's for that reason that we've taken separately court pay systems. We intend to do it for the Registrar General, and we intend to do it for the Licensing Authority and the Motor Vehicle and Trafficking Divisions.
Thank you, Honourable Attorney General. Just on a point of clarification, when you mentioned the specialty courts and you went through various gun court, drug court, etc., could you tell us at this point, I know Barbados and Guyana are moving towards the sexual offences court. Could you tell us whether this will be a priority in the next session of the Parliament in terms of bringing that legislation?
Yes, and I thank my learned colleague for the inquiry. We have drafted the sex offenders bill. It is out for public consultation right now. It is of burning and immediate priority for the government, which is why we did the legislation. As soon as we finish the stakeholder commentary in the course of the next couple of weeks, we intend to ask the Cabinet to consider the bill via the LRC process, the Legislative Review Committee, and we certainly intend to lay that bill in September. I might also add that it was for that reason that we moved with alacrity to operationalize the DNA regulations, so that after 18 years of having DNA laws on the books of Trinidad and Tobago, we can finally operationalize DNA.
Thank you, AG. Could you also indicate whether or not this would include legislation to effect the sexual offenders registry?
Yes, it is that I was referring to. So the sex offenders registry is to be done by way of legislation, because what is proposed is to treat with sex offenders on a registration basis in law, because it is something which affects a number of areas: passports, immigration, police, etc., protection orders. So specifically, the DNA laws coming into effect, the hard work of the member for Point 14 in operationalizing the DNA structures, in getting the 15,000 swabs, in getting in the legislation to treat with that, in perfecting the regulations, in building out the offices, in getting the DNA custodian, in getting the protective services. All of that excellent hard work that the member for Point 14 toiled to do is now about to come to life under these specialty provisions which the Criminal Division Bill specifically contemplates. In those circumstances, Madam Speaker, I beg to move.
Honourable members, the question is that this House agree with the Senate in the amendments to clauses 3 and 24(1) of the Criminal Division and District Criminal and Traffic Courts Bill 2018. All in favor say aye. Aye. Any against? The ayes have it. Honorable members, we shall go into the Committee of the Whole to resume consideration of the Anti-Terrorism Amendment Bill 2018, clause by clause. Committee of the Whole is now resumed.
Clause 26 revisited.
The question is that clause 26, as revisited, be amended in accordance with the draft now circulated by the Attorney General under list number 3.
Yes, Madam Chair. If I could explain. Madam Chair, the observations coming opposite include the position that what was being proposed by the Joint Select Committee was something which was going in a direction which should not be followed. The old language which the Joint Select Committee asked us to consider was that under 22AA and 22AA of the bill, of the Act, is what this clause treats with. So clause 26 treats with section 22AA, the capital E's. The language there was that the FIU should furnish the Attorney General with information required to facilitate an application under section 22B and section 37 spontaneously or upon request. The fine-tuned argument put forward lastly by the member for Oropouche East was that the old power in the old 2D, which read as follows, furnishing the Attorney General with information required to facilitate an application under Section 22B, where a designated entity has funds in Trinidad and Tobago, was something that was safer. We have described that pursuant to UN SCR 1373, that countries are now obliged, and it's right throughout the bill, to move beyond designated entities. So right throughout the bill, we've treated with individuals, entities, and designated entities. So in this amendment that we're circulating now, we're proposing to revert to the old language of 22A, AA, D, 2D, that we put here, that it would read such as, exactly as the old D said, furnishing the Attorney General with information required to facilitate an application under Section 22B in relation to, is what we're proposing is added now, an individual, an entity, or designated entity. So we are moving away from the FIU providing something spontaneously or of its own volition. We're removing the references to 22B, even though we're removing the references beyond 22B, which is Section 37, even though it exists elsewhere. So we're residing with what existed in the old Act as it is. This is the proposal that we ask the House to consider. I hope that I've explained it. I've provided a marked up version of what it will look like as well for honourable members to consider. And that marked up version is demonstrated in blue ink on the 22AA as circulated.
Might I just ask for clarification? The words "the relevant," which is how the amended section stands now, is that being deleted?
Out. Yes. So what we're doing is we're removing anything that said furnish the Attorney General with information beyond what the old D said. The old D was confined to designated entity. The UNSCR has moved beyond that, and right throughout the bill, you'll notice proposals for inclusion of entity, meaning listed entity, individual, etc. So what we're doing is we're maintaining that.
No, I've heard you, Attorney General, but what I'm asking is, I understand this further amendment goes, deals with the words after 22B. We have currently standing, 2 words have been inserted after the Attorney General with. So between with and information, 2 words were inserted, the relevant. And that was passed, so that it will mean that what we're being asked to do, I want to ensure that we all on the same page. The relevant is also being deleted?
We're resiling from what was considered previously, and the new amendment is before us.
Okay, all right, completely.
Yes.
Yes.
Saying about the word relevant.
She was looking at what was previously considered in the previous amendments and asking whether this amendment was to be superimposed on that. So for clarity, I'm saying forget what we did previously. That's off the table. We're proposing language as circulated, which takes us back to the old 22(2)(b)(d), except that we're going for entity and individual as well, beyond designated entity, because the FATF rules tell us that we must do that.
Member for Superior.
Thank you, Madam Chair. I appreciate the efforts of the Honourable Attorney General to try to reach middle ground on these amendments. Madam Chair, it is very difficult for us at this time to read these amendments within the context of all the other. I've already raised in this House the difficulty with the numbering. And you mentioned to me we couldn't change the numbering because you have 22A, B, B, A, capital C, D, E. It's very confusing.
Yeah.
I'm sorry.
No, it's okay.
So where it is now, we again know we have to look at these. I don't think I have had sufficient time to deal with such important amendments with respect to these provisions. I don't think many members of the House, or they may speak for themselves.
So, Madam Chair,
I want to make a
Sure.
humble suggestion.
Sure.
This is important to you, to us, and to the country. Can we be given the time, and then you also undertook to do 28 and 34, and let's come back on Monday.
could I urge my learned colleague to just, so we're not renumbering anything on this particular one. And the reason why I'd urge my colleague to please persevere is so that we can get on the record what would be, so that we can get into our minds what is acceptable. The position that came to us was go back to your old law.
Okay, fine. Madam, just on my first glimpse of this thing, reading it, some persons may say this is plain smart with nonsense in the way that you've put this particular amendment. Furnishing the AG, you take out 37, and you know that might be the only genuine one that you could do as the central authority. The AG is the central authority. Leaving the 22B, you're now coming back to every person in the country. That was our fear from the very start, that you may have an AG who is a fisherman who is fishing and seeks information on ABC, XY, PQ. That is still very much there. So just on a first reading of it, and that's why I'm saying we probably need a little more time.
So I've gone back
820.
at your recommendation to the old law.
Yeah.
The old law and the old powers, as Caroni Central put it, as Oropuch East put it, as Shogunas West put it, as Princestown put
AG
it.
that is being
Right.
smart with what I said before.
Yes, but so
Because it hasn't gone back to the original, with due
Okay,
respect. It hasn't gone back.
may I,
Sorry.
may I
It
ask
hasn't
this
gone
then?
back.
So if the old law said simply designated entity,
Yeah.
isn't section 22B the same 22B? The same Attorney General which has existed since 2005?
Yes. Yes, it is. Can you find 22B for me, please? 22B. Yeah. Yes, it is.
22B is on the same marked up version just in front of you. It's just under 22AA.
Yeah. Yeah, what's your question, sir?
Right. So if we're there, and it's the same formula, the same old law, the recommendation coming from the opposition was go back to your existing powers.
Yes, I agree.
Right. The only thing that needs to be caught now is how to achieve the FATF obligation that designated entity is too limited. They require you to treat with entity and with individuals. That's the only thing that is being added beyond designated entity. And that comes from FATF.
Sure. You know, in the earlier debate, earlier comments, we said, listen, designated authority, we have no problem with that. Designated entity, because there would have been a process outside of our jurisdiction to designate. They use the word designated, we use the word listing. you would have had a process outside of our country, who would send information to your good self through the central authority. Anything come from outside goes through the central authority. And then now,
No, it doesn't. It comes under 22B directly to the Attorney General and
22B
has,
of what?
of this law, it comes directly to the Attorney
Yeah,
General.
but that's one of the things we're trying to amend as well.
No, but you see, you said go back to the old law. The old law is exactly that. The old law has been since 2005, the Attorney General. I took your specific advice and I went back to the old law. The mischief, the concern which was pointed out was that any Attorney General can ask a Commissioner of Police for information and can ask the FIU for information. So further on, you'll see that we're chopping out entirely the Commissioner of Police giving the AG anything at all. We've cut that off. You'll see that in 22B, 1A, we delete it.
No, but I think we are dealing with 22AA.
Right.
We are not dealing with 22B.
Good.
So can we stick to the one that
Sure.
is under consideration? Because we confuse the
Okay.
issues with two different clauses.
So on
we are
22AA.
making arguments that are not relevant to the clause in front of us.
Okay, so 22AA
Yes, that's where we are.
says what the old law said. Furnish the Attorney General, same language in the old D, furnish the Attorney General. With information required,
Sure.
the old language with information required.
Yeah.
To facilitate an application under 22B, to facilitate an application under 22B. So a word text there.
Yeah.
The bit that changes now is instead of just being a designated entity, we are going to in relation to an individual entity or designated entity. Because the FATF rules say that that's what we must do, and we did it right through the rest of the bill. Is there a qualification in language that you wish to that?
I am saying you have extended the body of persons who can now be subject to this clause.
Right.
So do not please, humor me please, do not patronize me by saying,
I don't mean to come across that
that's
way.
right, I hope that's not the intention.
No, I
By
honestly
saying that
don't
you've
mean.
taken the old law and you've kept it exactly the same. Yes, you have up to a point.
Yes.
But you still come back and you have opened the seas, the
Okay,
ocean.
what do you
where
suggest?
the fisherman can fish.
What do you suggest?
If you want to do it, you go back there. Once you want to open every person in this country to this fishing expedition, the possibility of fishing, DDPP. I am very strong
Okay,
on that.
so-
I will have to consult with my colleagues as well. I mean,
So may I ask this? If it said just designated entity, exactly what the old law said,
no problem.
that would be of no problem for the opposition.
No problem whatsoever.
Okay.
Because you said it's been there 05, 6, 7, 8, 9, 10, up to 2018?
Correct.
Good. And you've been able to get how many orders?
357.
Yeah,
Yes.
yeah.
Okay?
So that's one aspect.
Got you. May we, with your permission, Madam Chair, in considering the agreement of the opposition, potentially, in respect of clause 22B, where we also propose an amendment, that would be clause 27. May I ask this question? We have proposed in the amendments that we've just circulated that we remove the provision where the Commissioner of Police would report to the Attorney General. We have owned.
AG, where are we?
One minute. Just one.
Are we on another clause?
Before we go to 27, I would suggest we complete the discussion on 26,
Well, no,
okay?
it's a 26. Yeah, 26,
Yeah, they
yes,
kept
yes.
the old one.
Yes, Madam Speaker, Madam Chair.
And we approve it, yeah. And we vote
So if
on
you're
it.
keeping the existing law, well, fine, we vote and take it. Or leave it.
On this clause, in the draft that we have circulated, Madam Chair, we will delete the words to an individual or individual, comma, an entity or, so it will just read a designated entity.
So we're reverting to the existing law, is that what it is?
Yes.
We will accept that.
Okay.
We stay with the law, we give the AG no additional powers here.
Should it please you?
and you will keep whatever powers you already have.
Yes.
Thank you very much.
Okay.
Okay, so the question is that clause 26 be amended as follows. And I will read it so that I am be assured that we all have it correctly. Open inverted commas, bracket, common D, close bracket. Furnishing the Attorney General with information required to facilitate an application under Section 22B in relation to a designated entity, semicolon, and close brackets. Is that it?
We have not been able to caucus on this. I agreed, but I have the whip removed from every member here. So I need to have a consultation. That's what I said earlier. I mean, you may operate with your one person tells you yes and everybody goes. In opposition, as you well know, Diego Martin Ortiz, you do have rebels. You remember?
Members, could we exercise some restraint and tolerance?
Yes, ma'am. Madam, what you've read is not what is the existing law. Right. It leaves out where this entity has funds.
in Trinidad and Tobago.
Madam Chair, I've heard my learned colleague mention the old words. Has funds in Trinidad and Tobago?
Yeah,
Sure, if it pleases you.
right.
Okay?
That's the existing law.
We will not pass recommendation 6 at FATF, but at least that's only in one part. And that was recommendation 6, which was agreed by your government. So I'm just putting it on the record. We will go with the old position, and we'll have to fight up with the international community on this.
Attorney General.
Yes, ma'am. So, Madam Chair, if you will add in those words, has funds in Trinidad and Tobago at the end of the sentence. Yes.
So just to ensure that we have it correct,
Where are we?
the amendment is as follows. Just let me read it to make sure before I put the question. Open inverted commas, open bracket, common D, close bracket. Furnishing the Attorney General with information required to facilitate an application under Section 22B in relation to a designated entity.
No, Madam, where designated
Where-
entity has funds in the entity.
Okay,
The identical and the black D.
Okay.
The black D, that is existing.
okay. So, open inverted
and white,
commas,
as the
open
agent
bracket,
says.
D, close bracket, furnishing the Attorney General with information required to facilitate an application under Section 22B where a designated entity has funds in Trinidad and Tobago, semicolon, and close brackets.
Yes, please.
What's that? Back to the original
Yes,
Parent
ma'am.
Act. Back to the original Parent Act.
So if we are back to the original wording, is
Exactly.
there an amendment?
This is the point. There should be no amendment. There should be none. You
Okay,
withdraw the
Madam Chair,
amendment. You have to withdraw
insofar
your-
as we've come for a full surgery, we can just delete paragraph B1. So the amendment would be to clause 26, delete paragraph B1, and therefore it'll revert to the old language.
Where is clause 26? I'm sorry, sir, would you be kind enough to repeat?
Yes, so the bill proposed that in clause 26B1, it proposed surgery to section 22AA-D in the manner that it did. So if we delete clause 26B Roman 1, there will be no amendment to
And it's
section
lower state.
22AA. Okay, so Madam Chair, the amendment would be,
Agreed, I hope that's how it will work.
yes. So the amendment would be delete in clause 26, delete paragraph B Roman 1.
Let's see what is clause 26, please. Can I see the original clause 26 in the amendment bill? You can have the red one.
But there's 22.
All right, let's go.
22. That's 22B. 26. Here.
These are the clauses, huh? 26, right, where are we?
22 here. And here 28.
29,
So where's 26?
yeah. You know, something is not right again, madam. When I go back to the amendment bill, which has been consolidated with the GSC amendments, I'm not finding any clause 26. Maybe I'm just not seeing properly at this time of the night. I'll be very happy if you can tell me on what page. What page? 377. Okay. 377.
Page
377.
376.
36, okay. Which is the clause we're looking at now?
26.
26. Page 377, I have a section, I have a clause 24, I have a clause 25.
Continue on.
376 is 23.
Okay,
I'm
so
not going
so
back,
continue
I'm
after
looking
25, just look for
for-
the
So
next
it'll be
clause,
378.
26.
37.
I apologize,
Where is it? This is 25.
right? Okay, are you seeing clause 26, section 22AA of the Act is amended?
You're saying this is
376? Every,
Well, use this.
okay. So depending upon how it was printed, some of the page numbers are
yeah,
different.
the numbers are different.
Right.
1 moment, where is it?
Clause 26. You'll see clause 26, the second line B,
Yeah, section 22.
in subsection 2 by deleting paragraph D and substituting this, so we're deleting B1 clean. So there's no amendment.
Agreed. Agreed,
Okay.
sir.
Thank you.
Okay.
We could have
So
saved a long
the question is that clause 26 be amended by deleting paragraph B1.
Yes, ma'am.
All right, so the question is that clause 26 be amended by deleting paragraph B, Roman numeral 1. Those in favor say aye. Those against say no. I think the ayes have it. The question is that clause 26, as amended, now stands part of the bill. Those in favor say aye. Those against say no. I think the ayes have it.
Clause 27.
The question is that clause 27 stand part of the bill.
Amended.
Attorney General.
Yes, ma'am. The government proposes, Madam Speaker, Madam Chair, clause 27, which proposes amendments to section 22B of the Act. Yes. Clause 27, which proposes amendment to Section 22B of the Act, there was a concern raised that an office holder in the Attorney General's office, whomever he or she may be, could obtain information from a commissioner of police, which could expose a political entity to police matters. That concern grounds itself in the Joint Select Committee's recommendation that 1A, capital A, which provides where a commissioner of police receives a referral from the Attorney General, under subsection 1, he shall, as soon as the results of the investigation are known, provide the Attorney General with relevant results of the investigation required for the purposes of making an application. To remove the concern, we are proposing to completely delete that clause. So the first amendment that is proposed, as appears, is to remove the requirement of the Commissioner of Police to provide in that language that information. That therefore takes us back to the old position of law. The next proposal.
Just can't. Can we take a break if you don't want to go home and come back Monday? It is very, very difficult to follow through permutations of these amendments. We haven't even read them properly.
Could I just ask
With due
that
respect.
we focus?
Yeah.
The mischief raised was, thank you, the mischief raised, sure, the mischief raised was that an Attorney General could be on some fishing expedition, as it was put, and that a Commissioner of Police could give him information. I pointed out that under other sections of the old law, the Attorney General has the ability to ask for information. We have 357 applications we've made at court so far, approved by the High Court. And to remove the concern of the opposition, which is contained in one clause only, one subclause, we're proposing to remove the subclause. Remove subclause 1, capital A. It is, yes, it is in blue, in strike through. There's only one clause in blue strike through that has been circulated. So we've done a marked up version for you. Yes? Turn it over. Right there, top of the page. Right? So it's straightforward. That was the concern raised. Caroni Central said revert to your old powers, Oropuch East, Chaguanas West. This is that. Madam Chair, would you, with the indications that they're okay, would you? It's not difficult, David.
In our amendments that we had proposed in clause 27 was about the Attorney General and the powers, right? Correct.
So they were proposed on the back of the fact that there was some new power being given, and the recommendation was to go for the old version. We're going for the old version.
So they can be on theirs.
So, delete proposed subsection 1A.
The old version is, well, remember that there are a whole set of them. You asked for notice to be provided. We've added in notice. You'll see it in the subclause 3A. It's in blue. So we've provided the notice. We've removed the Commissioner of Police telling the Attorney General anything at all. Is that agreeable?
Can you explain paragraph, the amendment B, Attorney General?
Sure. The request coming was that any person who was affected by an order of the court, the ex parte order, be served with a copy of the order. It's true that elsewhere in the rest of the law, that notice is provided, and the court always orders that notice go. But out of an abundance of caution, we've inserted the language to add that the notice be served.
Sorry. Yeah. Yeah, if I can just be a little bit presumptuous.
Sure.
Our original concerns that we had with Clause 27 was the Attorney General. Not you, but the Attorney General.
Understood. And it was on the back of the amplification of powers, as you put it.
Right. So that, for example, 22B, they had our Attorney General, we had recommended DPP.
Because of the amplification of powers.
In 1B, we had recommended DPP, had Attorney
No, I
General.
got you that, but your argument for the change to DPP was because that there was an amplification of powers. You said that these were new powers, and therefore the rationale was because these are new, let's move to DPP. So what we have done is to remove what you consider to be the amplification of powers. It's gone. That was in 1 capital E.
If I may, you may be totally correct. This side has not had a proper opportunity to read and study these amendments. And therefore, I am unable to say yea or nay, and may very well have to abstain on these amendments. We have not yet even seen the 34 and the whatever. We have not seen them. 28 and 34.
Madam Chair, to facilitate the fulminations, because my friend is correct, there's some connection between the clauses. With your permission, Madam Chair, we could discuss the clauses in general and then revert to them, because if Siparia is correct, if you agree to one here, how does it correlate to something else? So we have proposed surgery to the bill to take care of the concerns. So if that is permissible, Madam Chair, we can easily deal with it that way.
Go ahead.
Thank you. Thank you very much, and thank you, Attorney General. I just want to state at this time that one has to be very careful. Now, while I think we genuinely appreciate the extent to which the Attorney General is responding to some of the concerns raised, even the action to take off the entire 1A as a response to concerns raised, it is appreciated. But there are two issues I just want to raise. First, I really want to ask the Attorney General and the government to consider if it is possible to go through these amendments. There are some other matters too, smaller maybe, but there are some other issues. Is it possible that we can go through these issues, allow the opposition some time to look at it, and have another sit-in early next week and finalize it if we can? That's my first issue. The second, why I tell you, is that while it is good that you take away in a wholesale manner 1A, when we were at the committee stage, remember these things they are networked together, they are linked. There's a thread that goes through. Remember we had this issue in B, for example, where we said that the Attorney General shall cause an investigation to be carried out in respect of an allegation and may for that purpose refer to the Commissioner of Police, who may cause an investigation.
Yes.
And we had a debate as to how can an Attorney General mandatory cause an investigation to a Commissioner of Police who may investigate. Mm-hmm. But that was linked to this getting results and coming back to the Attorney General. Now, if we excise 1A as the proposal is, you still have this issue at the top, which now sounds even more cumbersome, that you shall cause an investigation to somebody who may investigate.
Turn over to section 25.3 of the existing law, which is what you asked me to do. 25.3 has exactly that language.
Okay, so it may be a problem repeating itself. I'm
Well,
not saying
yes.
I'm not saying it's not there in 20 whatever, but you understand that this was linked to the results feedback. Remember the concern you remember was that what happens now? You shall cause an investigation to somebody who may investigate. That's fine. You still incidentally here. I don't know how it will sync now, but you have in respect of individual entity and so on. That's fine, but is the Commissioner of Police, have you then given up on that policy objective almost, that the Commissioner would in some way give some feedback as to what has happened to all these matters?
So the key is this. There will be no obligation for feedback from the Commissioner of Police, but there's a positive obligation under the existing law, Section 25(3), for the Attorney General to cause an investigation, because you can't go to court without an evidence or information. So there's that positive step. You're referring it to the Commissioner of Police. He will do with it whatever he wishes to do with it. But he's not coming back under 1A to tell the Attorney General anything at all. He's not providing him. 1A is where he would have to have come back and give information. So that chops off the complete concern that was expressed during the discussions we've had so far.
Well, then I'm hearing you. Then you could also amend 22B, small b, because you can just have a referral to the Commissioner of Police. Just have a referral. The Attorney General shall refer the allegation or whatever it is there.
And that's what it's saying.
When you take off 1A, one big A,
yes,
you go back to B, you can amend that even further to say that you shall just refer it to the Commissioner of Police for whatever action deems necessary.
It's even safer than that. Where the Attorney General receives information on individual entity, etc., the entity control, etc., he shall cause an investigation. That's the language of 25(3). That's the existing law. That's how we went to court on the 357 occasions. And he'll refer that to the Commissioner of Police, who may cause an investigation. And that's it. It's there in the Commissioner of Police's hands. The difficulty was, as the opposition put it, this position of the Attorney General somehow getting information from the Commissioner of Police. So the recommendation from the opposition was rely on your existing law. That's what Carney Central, Chaguanas West, my learned friend from St. Augustine, you, Honourable Member for Oropouche, we've taken that position and we're not getting any information back. So this meets squarely and doesn't relate anywhere else. It is what you asked for.
At this point in time.
May I
just want the Honourable Attorney General, who's really trying very hard.
May I respectfully, sorry to interrupt, may I respectfully remind that this has yet to go to the Senate, where the UNC bench is present. And we therefore have an opportunity in the Senate to treat with this, where we'd have additional minds as well.
No. I'm not going to pass this on to 6 senators out of a Senate comprised of 32 people.
May I remind you that you can go in the Senate and then make wholesale amendments and come back here for a simple majority?
Okay, understood.
Okay. The question is that clause 27B. That clause. The question is that clause 27 be amended in terms of the amendment as circulated by the Attorney General on list number 3. Those in favor say aye. Aye. Those against say no.
Mr. Alwari,
Yes.
Dr. Rowley,
Yes.
Mr. Imbert?
Yes.
Mr. Young?
Yes.
Mr. Dialsing?
Yes.
Mr. Ford?
Yes.
Mr. Hines?
Yes.
Mr. Mitchell?
Yes.
Ms. Cujo?
Yes.
Mr. Garcia?
Yes.
Mrs. Critchlow Coburn?
Yes.
Mrs. Robinson Regis?
Yes.
Mr. Dillon?
Yes.
Mrs. Webster Roy?
Yes.
Dr. Gadsby Dolly?
Yes.
Dr. Francis?
Yes.
Mrs. Jennings Smith?
Yes.
Miss Oliver?
Yes.
Mr. Antoine?
Yes.
Mr. Leons?
Yes.
Mr. Smith?
Yes.
Mr. Lee?
Abstain.
Mrs. Prasad Bisasa?
Abstain.
Mr. Charles? Dr. Rambachan? Mr. Karen?
Abstain.
Dr. Tiwari?
Abstain.
Dr. Munilal?
Abstain.
Mrs. Gaideen Gopi Singh?
Abstain.
Mr. Indar Singh?
Abstain. Abstain.
Mr. Ramadan?
Abstain.
Dr. Khan?
Abstain.
Mr. Padara?
Abstain.
Dr. Budo?
Abstain.
Mr. Pari?
Abstain.
Ms. Ramdial?
Abstain.
Mr. Singh?
Abstain.
The result of the division is 21 ayes, 16 abstentions, no against. So I now put the question. The question is that clause 27, as amended, now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Clause 28.
The question is that clause 28 stand part of the bill. H.E.
Madam Chair, the government proposes that we agree with the opposition's observation that, in this one we had noted that committee was the old language, and what we have proposed here is that we use the formula that the Joint Select Committee had done, and that is instead of the word "the committee," which is no longer a part of the bill, we use the 1267, 1989, and 2253 committee. It's just to harmonize the language elsewhere. The opposition had proposed that we cause an annual report to be laid. The government has suggested language to that effect, the insertion of a new 22BF, where the Attorney General shall cause to be prepared and laid in Parliament an annual report on the number of entities listed in accordance with Section 22B. I've seen the Honourable Leader of the Opposition's amendments that be slightly broader to include matters including orders, etc. The language proposed by my learned colleagues is agreeable. The language proposed is in need of a small bit of surgery because the entities may be more than listed entities. So we propose that we delete listed entities. And because one could not tell where an ongoing prosecution was, we just simply prefer that we treat with number of prosecutions. So the matters circulated by the opposition would have read or do read as follows. Annual report, the minister shall cause to be prepared and laid in Parliament an annual report on the ongoing prosecutions, convictions, a list of listed individuals and listed entities, and any orders made, whereas our own proposes the Attorney General, so we've named the minister because it is the Attorney General, shall cause to be prepared and laid in Parliament an annual report on the number of entities listed in accordance with Section 22B. We can add to this language, comma, the number of prosecutions,
So, Attorney General, might I ask, you are moving a further amendment to what has been circulated? Because nothing yet has been moved by the opposition. So is it that you are moving a further amendment to your 22BF?
Yes, ma'am, and I'll explain how and why, and the very simple language. The opposition proposes the concept of an annual report. They propose it under a new clause 46. We can neatly take care of that observation in the existing clause 28 by putting in language to marry what we have here in the circulated version. So we propose and agree that an annual report be done. We've said that the Attorney General prepare that report and lay it in Parliament. We went so far as to say the annual report should be on the number of entities listed in 22B, because that's all that the Attorney General does. The recommendation in the new clause 46 that the opposition had proposed went further and said the number of prosecutions, convictions, and orders, because the orders would include the designated orders, for instance. So we propose to do some surgery to the language which we have circulated. At the end of the paragraph which we propose, that is just after the words Section 22B, yes, we put in a comma and insert the following: the number of prosecutions, comma, convictions, and any orders made pursuant to this act. And that would therefore capture everything that is in the act. So we propose to borrow from the language of the proposed clause 46, new clause 46, and just add it into our amendment.
Leader of the Opposition.
The proposed amendment we had is a new clause 46. The AG is right, it can be inserted here, but we put it as a new clause out of convenience. We were raising an entirely new issue that was contained nowhere in the amendment bill. So we wanted to insert the annual report. However, I don't think the AG is now agreeing it is the Minister shall lead this and not the Attorney General.
So that would be the Minister of National Security?
But this bill, if you recall, in clause 5, the definition section, does define who the minister is.
It does?
It does.
But
And the reason why I thought of the AG is the minister instead of the AG is because it's a wider remit of things. There's prosecutions, convictions, and so on, which will fall under really national security.
We can take it that way as well?
We can consider that.
It
So
would feed in.
instead of you see, the AG's role in this, which we have not yet totally agreed to, is with the orders made. But that can be obtained from national security.
Sure.
When the minister is causing the report. So I would humbly suggest you adopt our words and you leave out the AG again AG has a lot of work to do.
So, Madam Chair, if that's the
Let's
proposal,
leave
then
the minister
we
for
can,
national security.
because the member is correct, there are two ministers, quote unquote, involved here. One is National Security and one is Attorney General.
Right.
So insofar as the National Security Minister is defined, we can do that in a new clause 46. That is not a problem, in which case the government can remove its proposed amendment at 28B, capital B, and we could just stick with 28A.
Which will make matters easier too.
Yeah?
So we can just vote on the 28. Yeah. What is
The question is that clause,
We also have amendments to clause 28, but it does not affect the government's 28 capital A. So if we do that way, we still have, Madam, a lot of other proposed amendments to 28. So I have not received anything from the Honourable Attorney, from the government on their proposed changes to 28. We got 26 and what?
Yes, so the clause 28 proposed amendments by the opposition tied back to 22AA and 22B, where the opposition submission was that the Attorney General was receiving something for the first time, which we disagree on, but which we have now sorted out. So these cascading amendments that the Attorney General be substituted by central authority, which is the Attorney General, etc. These amendments, I think, in light of the removal of the concern in 22AA and 22B, I'm submitting that they are no longer necessary. But that would be something for you to consider.
What is no longer necessary? Our proposed amendments to 28?
Perhaps I should let you articulate the amendments then?
Well, it's circulated here.
Okay.
It's circulated on page 3 of our circulated amendments.
Right.
This is a clause, in fact, where the central authority is being proposed. I know with clause 22 and 26 members on the other side, we're talking about central authority.
Oh, right.
This is where the central authority
This is
pops
the one
its
that
head.
we're going to delete, right?
Finally.
Yeah. Madam Chair, forgive me. There is something that we omitted because we had not circulated it, but in picking up on the submissions, if members look to 22BE, which is what the circulated amendments of the opposition include, in BE, capital B, capital E, Attorney General to receive requests for declaration of listed entities. Yes? Okay. Subclause 3, in light of the amendments that we made at 22A, AA, and 22B, we would need to delete subclause 3.
Why are these underlined? Why
Yes,
is it underlined?
to be consistent with the amendments.
Then why
So
is
we're
it underlined?
proposing that we delete 22BE subclause 3 to be consistent with what we did in clause 26 and clause 27. Sorry, 4. It's 4, right? Not 3, it's 4. Subclause 4 is where the Commissioner of Police receives a referral from the AG that he must inform the AG. So, consistent with the amendments we just made to clause 26 and clause 27, we're proposing to remove the Commissioner of Police telling the Attorney General anything. It means, therefore, 22BE, the request from the opposition is change Attorney General to central authority. The Attorney General is the central authority. And therefore, I respectfully submit that it is the same person, same entity.
(22BE4),
Yes,
the entire clause 4.
in its entirety. Delete the whole subclause 4. That will keep us consistent with what we did earlier in clause 27.
Now, we had also proposed a clause 4, where the Commissioner receives the referral from the Central Authority under subsection 3, he shall, as soon as the investigation can provide the Director of Public Prosecution a report of the investigation for the purpose of making an application.
Got you. And my submission to that is that that's what the DPP would have to do anyway. The police and the DPP work hand in hand.
So what does that mean? You okay with this clause?
No, well, it's not necessary, because actually what will happen is that you're going to compel a step between DPP and police.
There's another matter. Again, if you delete 4, the next one, which in my markup here looks like 4.5, where on the basis of an investigation under subsection 3, the Attorney General is satisfied. But you have subsection 3 to remain, where the Commissioner of Police may cause an investigation.
Yes.
But how could the Attorney General be satisfied if he didn't receive any results or feedback or whatever?
Because of section 25.3. So section 25.3 says, in the old law, wherever the Attorney General has to do something, he shall cause an investigation.
Right. Who investigating?
The Attorney General would have to do his own investigation.
So the Attorney General becomes an investigator in the matter?
The investigation which is done is that you cause inquiries to be made and you condescend to them in an affidavit.
No, but
And that,
how, you see, this is a problem was raised before. How, under what law, under what administrative structure as well,
Sure.
does the Attorney General cause an investigation? Does the Ministry of the Attorney General
Sure.
house investigators,
Sure.
police officers, detectives?
Yeah.
That was
Yeah.
an issue raised.
So I can
who is
answer you.
who is investigating? And when you get these results of that investigation, which may not be the police, then you act under 4.5.
Yes, so let me answer with it. So the specific law which provides for this is the Anti-Terrorism law since 2005.
Right.
Section 25.3. It's been done 357 times already by 357 orders of the High Court of the Republic of Trinidad and Tobago between November 2015 and today's date. Secondly, the causing an investigation to be done is so that there's a positive obligation to present evidence to the court. What that investigation involves is what those 357 affidavits have stated. This is what was done. We wrote off to X place. The Attorney General under MLAT asked for so-and-so, but from the Mutual Criminal Assistance in Criminal Matters Act, we referred something to the Commissioner of Police. We don't know what's happening there. We referred it to the FIB. We referred it to the FIU, etc. And that's what an investigative step is, because the FATF requirements, which cause Section 25.3 to come to life, since 2005, straight through to today's date, they say that you can't just act capriciously. You must take a positive step. So this has been the law for a very long time now, and that's the answer to the position. But I'll remind as well, these referrals come under, for instance, entities such as the ACIB, the Anti-Corruption Investigation Bureau, which under Attorney General Ramesh Lawrence Maharaj came to life and received requests for investigations, etc. So there are multiple avenues that exist in law and have for a very long time.
Central Authority.
Member for Siparia.
Madam, again, I cannot, I cannot marry all these clauses together, and therefore I am not in a position to say yea or nay to the proposed amendments, and therefore we may have to abstain on this particular amendment. It may all be very well good, but this thing is so interlinked, one clause to the other. This piecemeal way of us looking at it tonight with the greatest of vexation. I know how hard you're trying. You may be doing it perfectly well, but we are not in a position to say yea or nay without reading the thing in the entire context. So that is my submission, respectfully.
I understand my learned colleague's position. It's for this reason that we went to the Joint Select Committee and spent 15 sessions managing this affair. So the correlations here, what is definitely observable is that 22BE4 should come out, consequent with the amendments we just made to clauses 27 and 26. Once that comes out, all that's left on the table, by the opposition's recommendation is change Attorney General to central authority, and I'm saying Attorney General is central authority. So we're in a safe zone there. So the two match up, because nobody else is the central authority other than the Attorney General.
Putting central authority, if it's one and the same.
Well, that was your recommendation, put in central authority, and I'm saying central authority is the Attorney General.
And device, just go outside, please, and deal with it. Thank you.
Yes, ma'am.
Saffron West.
Yes. So Madam Chair, in clause 28, the government proposes that there be a deletion of 22BE subparagraph 4 with a consequential renumbering, which will flow automatically, so we don't need to say that. So we propose that clause 28 be amended by the deletion of section 22BE subclause 4.
Honorable members, the question is that clause 28 be amended as follows. A, in the proposed section 22, capital letters BB, delete the words, open inverted commas, the committee with a capital C, close inverted commas, wherever they occur, and substitute the words, open inverted commas, the 1267, 1989, and 2253 committee with a capital C, close inverted commas, full stop. And also to delete subclause 22, capital B, capital E, subclause 4.
Yes, ma'am.
Those in favor say aye. Those against say no. I think the ayes have it. The question is that clause 28, as amended, now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. I think it was clear. Madam Clerk?
Mr. Alwari,
Yes.
Mr. Dr. Rowley,
Yes.
Mr. Imbert,
Yes.
Mr. Young,
Yes.
Mr. Dialse,
Yes.
Mr. Ford,
Yes.
Mr. Hines,
Yes.
Mr. Mitchell,
Yes.
Ms. Cujo,
Yes.
Mr. Garcia,
Yes.
Mrs. Critchlow Coburn,
Yes.
Mrs. Robinson Regis,
Yes.
Mr. Dillon,
Yes.
Mrs. Webster Roy,
Yes.
Dr. Gatsby Dolly,
Yes.
Dr. Francis,
Yes.
Mrs. Jennings Smith,
Yes.
Ms. Oliver,
Yes.
Mr. Antoine,
Yes.
Mr. Leons,
Yes.
Mr. Smith,
Yes.
Mr. Lee,
Abstain.
Mrs. Pasabi Sessa,
Abstain.
Mr. Charles,
Abstain.
Dr. Rambacham,
Abstain.
Mr. Karen,
Abstain.
Dr. Tiwari,
Abstain.
Dr. Munilal,
Abstain.
Mrs. Gaideen Gopi Singh,
Abstain.
Mr. Indar Singh,
Abstain.
Mr. Ramadan,
Abstain.
Dr. Khan,
Abstain.
Mr. Padara,
Abstain.
Dr. Budo,
Abstain.
Mr. Pari,
Abstain.
Ms. Ramdial,
Abstain.
Mr. Singh,
Abstain.
Honorable members, the result of the division is 21 members for, 16 members have abstained. There have been no members voting against. The result of the division is that the amendments are now carried. May I ask whether we can take clauses 29 to 33 as a block?
But
Okay. 29 to 33. Okay. I've been told we did 29 to 33 already, so can we do clause 30? Clause 34. I'll
No.
take you.
Bring to your attention Standing Order 70. Procedure in Committee of the Whole House on a bill. The clerk of the Committee of the Whole House shall call the number each clause in succession, so we are now going to 34. The chairman shall pose the question to the clause stand part of the bill. B, a discussion shall ensue, during which amendments may be moved. Amendments must be in writing and handed to the clerk for circulation. We did one just now, that didn't happen. We're going to do 34 again, we have nothing before us, and the maze makes it very clear as
We
well.
have your amendments, which we're going to consider on 34. So the
Yes.
only amendments left are yours. And we've done that before.
Just a minute.
We have.
Just 1 minute.
Just for clarification, please, madam.
Just 1 minute. Even though we have the standing orders, I'm also of the view that the House regulates its procedure. We took the other clauses where there were no objections by agreement earlier, and we left the matters that were contentious for now. As far as I understand, we're now on to clause 34, but I only have one amendment before me. So that I take it that there's no amendment coming from the government.
There will be, consequent upon what we decided in other clauses to harmonize, we would need to delete a particular provision which went in, which is again where the Commissioner of Police is obliged to give information back to the Attorney General. So we will be proposing a simple deletion, which could be taken in the body of the amendments proposed by the Leader of the Opposition.
Okay. Leave that for the discussion, and then we will see what happens. Okay, so that.
Clause 34.
The question is that clause 34 stand part of the bill.
Madam Chair, to take care of the amendments proposed by my learned colleagues and in conformity with the amendments made to clauses 26 and 27, we propose.
Attorney General, might I suggest, because what is being circulated here, I turn to the Leader of the Opposition, let her propose her amendments, and then you can, all right? Please, Leader of the Opposition.
I beg to move that the amendments as proposed in the list of amendments circulated by the opposition with respect to clause 34 be considered by this committee. They are to be found at page 4 of the 5-page document which has been circulated.
Madam Chair, we agree with the Leader of the Opposition's proposed amendment at clause 34B, where the Leader recommends that we delete the proposed subsection 3A. If subsection 3A comes out, then we fall back to the old law, and therefore we are suggesting that there would be no need to change Attorney General to DPP, consistent with what we did in clause 26, clause 27, and clause 28.
Section 25, please. 25. 25, 3. Where the age receives information. Section 25 is. Subsection 3A. Which is the other one? Which is very offensive, regrettably, but
Well, it meets with MLAT.
it's not for consideration by us today.
I apologize. I didn't turn my mic on.
Madam Chair, I just want to say it.
Member for Point of Appeal, yes?
Yeah, sorry, Madam Chair, given what we have been going through here, and the Attorney General, with all due respect, the change that he has suggested based on what we had suggested might be all well and fair and fine, but we really need some time to really look at these amendments. I mean, given, we've been at this thing,
We could break for 2 hours.
some of us, I want to be fair, that some of us have been looking at this color-coded thing for hours now.
So let's come back.
And after a while, it does start to play on your eyes, Madam Chair, and that's with all due respect.
No, that's okay, but it's the interconnection, sorry, madam, it's the interconnection of the clauses.
Correct.
When you read one part of a clause, you read about 30 other pieces. What do I think it is? A very complicated bill.
Members, please. Member for Carnegie
Yes.
Central. I
Madam.
recognize the member for Carnegie Central, please.
Madam Chair, I want to endorse the position of the Chief Whip and the Leader of the Opposition. The Attorney General himself, in the presentation of these things, have made very, very small errors along the way, which is corrected. You yourself, Madam Chair, you just made an error which you corrected. I think what has happened is that the inundation of all of this information with all the color coding and trying to make ultimately coherence of it presents a difficulty. This is a big, important bill with national and international implications having to do with the management of terrorism as well as the management of the civil rights of the people of Trinidad and Tobago. I would suggest humbly, in keeping with the position of the Leader of the Opposition, that we go home, come back, deal with this coherently, and finish the bill on another day of your choosing.
Madam Speaker,
Martin West.
Madam Speaker, Madam Speaker, I just want to go on record to tell the opposition that we understand exactly what they're doing. The opposition has no intention of voting for this bill. And all they are doing, Madam Speaker, is obstructing and delaying, and they have no intention of voting for this bill. Madam Speaker, when we met...
Just a minute, please. Honorable members, I appreciate it is late. Member for Couva South, please, and member for Oropouche East, I've told you that I do hear you. Okay? I know it's late, and I'll just ask us all to find within us what might be the last threads of tolerance and respect. Let's hear each other. Okay?
When we get tolerance and respect, we can give it back, madam.
Member for Superior. Member for Superior. I would also say again that I think it's late and we all need to be tolerant. And I keep reminding us of something that the member of Tabakit has said. If we all take an eye for an eye, we'll all be blind. Member for Diego Martin.
Madam
West.
Speaker, the government has heard the opposition on a previous day with respect to these amendments. We went away, we had offerings to the opposition, we had meetings, time has passed, nothing happened. The opposition has not cooperated outside of this sitting, outside of this chamber, to advance anything. We've come back here today, we are going through the amendments that they themselves have put. And all of a sudden, they can't understand the amendments because they have to go to the bathroom. They're tired, they're sleepy, they're weary. And now they're asking us, Madam Speaker, they're asking us to stop the work, that they have got.
Member for Diego Martin West, a minute, please. Member for Princess Town. Member for Diego Martin West. Member for Diego Martin West, please. Member for Princess Town. Member for Princess Town.
Madam Speaker.
Member for Diego Martin, notice.
Asked to speak, Madam Speaker.
And that's why. It's because you didn't ask to speak.
Madam Speaker. AG.
Madam Chair, I am humbly requesting, please, to my learned colleagues all, with respect, right? Okay. If I could just ask us to please focus, we have one more clause, just one more clause. Could I please just ask us to focus on this?
The allegations being made against us.
Please. I recognize the member for Superior.
I thank you very much, Madam Speaker. First of all, on several occasions in the committee
Members,
stage.
I've
No,
just
please.
asked. Member for Superior, 1 minute, please. Members have asked us all to calm down and be respectful. I give audience to the member for Superior.
Thank you, Madam Chair. It is totally untrue that we came to this committee stage with every intention not to pass this bill.
Correct.
That is totally untrue. We could have not even presented any amendments. Let's start there and just come here and say no. Can I have my turn to speak? Others can speak after. We came in the committee stage with amendments, one, which we had signaled since the debate. We came here today.
Please, just 1 minute, please. Member for Superior.
We came today, several points put by the Honorable Attorney General, we have accepted. In fact, we tried to signal how much we were in support of this by asking for divisions along the way. Because we know the news that will go. Is there a thing?
I will grant you an opportunity to speak in the proper way. All right? Please. Member for Superior.
So the allegation is being made by none other than the Honourable Member for Diego Martin West, that we have no intention, is scripting a narrative out there, that is what we came, and that is not the case. And I want to put it on the record. We very much would like, look, our members in the JSC raised concerns, even from then. I told them, look, you all sign through with it, we will work it through at the committee stage. So at every point, we have been willing to cooperate. We agreed to the JSC, we operated in the JSC, yes, we signed the JSC, so it is therefore it is not true to say that we never intended to support this matter. The Parliament is not a rubber stamp for a JSC. Even the government on its own has come here with amendments to what they signed off in the JSC. Today's amendments. And that is why the Parliament has the last say. And not just this House, the other place too. So you cannot accuse us of going against a JSC, and we will not rubber stamp. Totally untrue, that we did not intend, will never support the bill. Totally untrue. I place that on record here today.
Right. Attorney General.
Thank you. Madam Chair, I appreciate the submissions of all my colleagues. I understand that this is important for all of us. We're nearly at the end. We have one clause effectively left. This particular clause that we're treating with right now, the amendment to this clause that the JSC proposed, clause 25, that, yes, so clause 34 treats with an amendment to section 25 of the Act. The substantive amendment that this clause was causing was the insertion of this position that the Commissioner of Police should tell the Attorney General the results of his investigation. We have recognized in clauses 26 and 27 that we should remove that. All that I am proposing is exactly what has been proposed by the Honourable Leader of the Opposition, that we delete this subsection 3A. That's in the amendment proposed by my learned colleague, Siparia. So I agree with Siparia that we remove this 3A exactly as is set out in recommendation B. With that, now, clause 4, the recommendation to delete section 4A is something which didn't feature in the bill itself. So 4A is not being amended at all by the bill. This 4A, even though prescriptively we can't treat with it, 4A says the Attorney General and DPP shall consult in relation to international law practice, international relations, and prosecutions by a foreign state. That is just an acknowledgement of the Mutual Assistance in Criminal Matters Act, where the central authority does that under that legislation. So it's not something that is untoward. It's been in existence since 2005, straight to today's date. I just wanted to address it, even though technically the bill doesn't treat with it, and therefore we can't delete 4A. The position is that this is exactly the mutual assistance for extradition issues that the AG and the DPP treat with. It's been the law since 2005. So we agree with the opposition, remove the reference to the Commissioner of Police giving information to the Attorney General, and therefore respectfully, that then takes care of the need to change from AG to DPP and that constitutional argument. So we've given that which was asked. I'm asking honourable members opposite, this is a very simple position here, to treat with it and treat with that position. We have one more clause after this to treat with, effectively.
You want a little time?
Opposition is the same, madam. I am unable to say yea or nay at this point in time. B, there's a part A, which I still stand on with respect to the role and powers of the Honourable Attorney General.
Okay.
So don't say my own.
So, Madam Chair, I understand my learned colleague. The recommendation coming from the opposition that you install the DPP came on the back of three clauses. Clause 22, Section 22AA. where the FIU was giving the Attorney General something. That's been amended to take care of that. Section 22B, where the Commissioner of Police was giving the Attorney General information, we removed that. The third one is Section 25, as it is set out here, 3A, we're removing that. If those have been removed, then as Caroni Central put it, as Oropouche East put it, as Chaguanas West put it, we're going back to the old law. And the old law is what we've been assessed on. We've been assessed by FATF in 2005, 2010, 2015, first round, second round, third round, fourth round, mutual evaluations. They've assessed this law. So that causes us to go with the law that we have, the existing law. So in those circumstances, I'm asking my learned colleagues that we accept the deletion as proposed by the Leader of the Opposition of subsection 3A only.
Does it satisfy what you asked for?
No, I'm not understanding nothing.
Does you worry? He's referring to your suggestions.
Member for Superior.
Yes, madam. I made my position unable at this point in time to say yea.
So could
or
you
nay.
put the question that?
All right. So the question is that clause 34 be amended to delete subclause subsection 3E. Those in favor say aye. Aye. Those against say no. Any abstentions? I think the ayes have it. The question is that clause 34, as amended, now stands part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
New clause 46.
No, please, it's subsection 4A. That has not been put.
I see to put each one.
Well, madam has only done one. So what will happen to the rest of them?
I think she put it as the government's recommendation in light of yours. So you'd be correct, Madam Chair. You would have to put the Leader of the Opposition's recommendations. This is simple.
The question is that clause 34A be amended as follows. The question is that clause 34 be amended as follows. In subsection 3, delete the words open inverted commas, the Attorney General, close inverted commas, and substitute the words open inverted commas, the Director of Public Prosecutions, close inverted commas, wherever it appears. Those in favor say aye. Aye. Those against say no. Members, could we just have everybody's attention to make this process easy? The question is that clause 34 be amended as follows. In subsection 3, delete the words open inverted commas, the Attorney General, close inverted commas, and substitute
Madam
the words...
Chair, I'm sorry to interrupt you, but perhaps it is in the best interest that we do cause an adjournment. I believe that the Leader of Government Business may wish to intervene at this point.
Madam Speaker. Madam Speaker, I think given what the members of the opposition have been saying, that we will adjourn to Wednesday. Do you need to resume the House, ma'am?
Yeah, but
Yes.
I will just, if I anticipate
Yes, ma'am.
what is being proposed, the clerk will give you the procedure.
Madam Chair, in accordance with Standing Order 7014, I beg to move that progress be reported to the House.
The question is that progress be now reported to the House. Those in favor say aye. Those against say no. I think the ayes have it. The House will now resume. This committee session is suspended. Attorney General.
Speaker, in accordance with Standing Order 7014, I wish to report that progress to the bill was made, clauses 1 to 34 of the bill, and that they were considered in the Committee of the Whole. I seek the leave of the House to sit again on Tuesday, the 3rd of July, 2018, for the resumption of the proceedings.
Is the House prepared to grant leave? Yes. Leave having been granted, honorable members, leave having been granted, the committee stage of the Anti-Terrorism Amendment Bill 2018 will resume on Tuesday, the 3rd of July, 2018. Leader of the House.
Thank you very much, Madam Speaker. Madam Speaker, I beg to move that the House to now adjourn to Tuesday, the 3rd of July, 2018 at 1:30 p.m.
Honorable members, the question is that this House do now adjourn to Tuesday, 3rd of July, 2018 at 1:30 p.m. All in favor say aye. Aye. Any against? The ayes have it. This House now stands adjourned to Tuesday, 3rd July, 2018 at 1:30 p.m.